So we are now going to move on to the vendor arrangements, but the issues that we have discussed in respect of the implementation partner will also apply in respect of the vendor arrangement. But there are some additional considerations we think that will apply in respect of data security when you are looking at the vendor arrangement, which we'll take you through now.
So in addition to having adequate security measures in place with your vendor, the customer might also want a warranty that the vendor solution or the SaaS solution will be secure, and also that the customer's data and the customer's systems, if it's integrated, will also be secure. The language that you will get will largely depend on your bargaining power. Most vendors are going to bulk at warranting complete security, but I think it is reasonable to ask for a warranty that the SaaS solution doesn't contain any viruses, backdoors, or other harmful code.
From a vendor's perspective, I operate a one-to-many service, and what I mean by that is that I offer one solution that is the same to all of my customers. And if a customer requires me to sign up to some bespoke obligations or bespoke security requirements, then I would struggle with that on the basis that that would mean I could no longer offer a scalable solution to all of my customers at low cost. Instead, what I might do is be able to offer you as a customer assurances around the security of my solution. As I mentioned at the start, as a supplier, I might have front-footed this discussion with you, knowing the nature of the data that is going to be involved in the project. But if I haven't, then at this point in time, I would perhaps present you with my audit report that shows I'm compliant with ISO, or my SOC 2 report that shows that I meet verified industry standard security measures. And so in that way, I would hope to get the customer across the line that my solution is secure enough to hold their data.
And so that brings us to storage. In terms of storage, it is important as a customer to understand the locations where your data will be stored or otherwise processed by your vendor. Some vendor form agreements will expressly reserve the right to store and or back up customer data in several countries around the world. And while dispersed geographical storage can be beneficial from a redundancy perspective, if personal information is involved, then it can be problematic. So for example, if your data includes personal data of EU data subjects, then depending on the locations of storage, you might need to ensure whether you need to put in place adequate onward transfer mechanisms with the vendor. Now this is because New Zealand currently has adequacy status under GDPR, and that means that personal information can be transferred from the EU to New Zealand without the need for additional safeguards in place. But any onward transfer outside of New Zealand to a location that doesn't have adequacy status will mean that you need to consider putting in place an adequate onward transfer mechanism, such as, for example, the standard contractual clauses. And this is also relevant here at home in New Zealand under the new Privacy Act, which I mentioned earlier, which will introduce a new privacy principle which places restrictions on the transfer of personal data to organisations offshore. Importantly, the new information privacy principle won't apply where you are transferring personal information to a service provider who will hold it solely and process it solely on your behalf. So it's an agency type relationship, as that won't be deemed a disclosure of the information for the purposes of the Act. But where your service provider, in this case the vendor, will use the data for their own purposes, then you need to consider whether the transfer of the location outside of New Zealand will be compliant under the Act. And so generally speaking, if an individual has authorised the disclosure, then it will be fine. But if you don't have the express authorisation of individuals, then you will need to ensure that the information will be protected by safeguards that are comparable to New Zealand's law. Examples of how you can achieve this are by imposing contractual data protection obligations on your vendor that are comparable to the protections under the new Privacy Act. or by ensuring that the vendor is subject to the laws of another jurisdiction that have comparable safeguards, so that you would be limiting storage to certain jurisdictions which have so-called adequacy status in GDPR terms.
So from a vendor's perspective, I think one of the benefits of using a one-to-many solution for my customers is that customers are able to take advantage of improvements that I make to the solution based on the experiences of other customers. And in order to do that, I will look for the ability to potentially use the way in which the customer uses my solution to improve my services. So generally speaking, I may look to use the customer's data on an aggregated or non-identified basis in order to, for example, improve my solution. And on that basis, on the basis that it is non-identifiable information, I would hope to assure the customer that this would not trigger the disclosure obligation under the new Privacy Act. Of course, if I do want to use data for other purposes in an identifiable way, and it's personal information, I want to use it in an identifiable way, then as a vendor, I need to be aware that that may trigger that disclosure obligation for the customer, and that the customer is likely to pass down contractual obligations to me unless I'm located in an adequacy in a geography that has adequacy status. The customer is likely to pass down to me contractual obligations that ensure that my use of the data complies with the Privacy Act.
So then another important issue to turn your mind to is business continuity and data recovery, particularly now that we have COVID. As a customer, you would want to understand the processes that the vendor has in place for moving up and down alert levels, and how that might affect your ability to access your data, particularly if you receive, for example, a request from an individual for access to their data.
Again, I think from a vendor's perspective, this really depends on the nature of the SaaS solution that I will offer. So many SaaS solutions allow the customer to have access to their data at all times. So if that is the case, then I am likely to push back on any additional obligations to allow access to that data. I would also expect that the customer, because they can access the data, would have and maintain their own backups of that data.
So then looking at breach, as a customer, you would want to ensure that the vendor is contractually obligated to notify you and to take other steps in the event of an information security incident involving data that they hold. This is really important because if your confidential information is compromised, then that could cause you significant harm. But it is also really important where your data includes personal information, because under the new Privacy Act, there are mandatory notification requirements in relation to serious data breaches. Now, we're not going to go into the detail of what constitutes a serious data breach in this seminar. The obligation under the Privacy Act is to notify as soon as practicable after becoming aware that a notifiable privacy breach has occurred. And so as a customer, you might want the vendor to cooperate fully and promptly in any investigation of a security incident involving your data that they hold. You might also want to control or have some control over public announcements relating to any such breach, as your reputation can be at stake, especially if your customers know that you use this vendor to store data. And you might also look for remediation obligations to ensure that similar incidents don't happen in the future.
Now, from a vendor's perspective, in terms of obligations in the event of a breach, again, as I offer a one-to-many service, I'm highly motivated to ensure that my solution is secure and that any data security incident is dealt with quickly and in a way that limits harm. And that's because, again, if there is a data security incident on my solution, it's unlikely that only one customer is affected. It's likely that many customers will be affected, and that will would be harmful for my reputation and business. So I'm very motivated to get it resolved very quickly. Again, I would push back on taking on bespoke obligations to any particular customer and how I deal with a data security incident. Instead, I would offer the customer the process that I offer to all customers in respect of dealing with data security incidents. Now, given the damage that this could cause to my reputation and my business, I would also want to work relatively collaboratively with the customer in terms of going out and making public statements in relation to any data security incident. Of course, I acknowledge that there will be requirements under law that the customer will need to comply with, but outside of that, then I wouldn't be looking for the customer to, at the very least, consult with me in terms of any public announcements that are made.
And so then in terms of return and deletion, as a customer, you might want to ensure that you have the ability to require the vendor to return and delete your data or a subset of your data at any time during the term of the agreement. You would also want the vendor to return and securely destroy your data automatically on termination or expiry. You might also want to consider whether you need transition services from the vendor upon termination or expiry.
I think, again, from a vendor's perspective, this will really depend on the solution that I offer and how accessible the data is to the customer during the term of the arrangement. Now, if the data is accessible to the customer, then I would expect that the data or the customer would be responsible for obtaining the data and having access to that when they need to. In terms of transition assistance, should the customer not have access to their data, then of course I would be willing to provide transition assistance, but I would also be looking to charge for that, for those services. Now, one thing to note, as a supplier, I may have obligations to retain customer data as a matter of law, and so I would also be looking to carve out in any obligation to return or delete data that I agree to, the right to be able to maintain or keep data for as long as I need to in order to comply with those legal obligations.
And so just picking up on charging for transition services, that might depend as a customer whether I'm willing to pay for those transition services. That might depend on what has caused the relationship to come to an end. So if as a customer I have terminated the agreement for cause because the SaaS solution isn't performing to standard, then I might actually expect that the vendor provides transition services to me free of charge.
So that's actually all Sarah and I had to speak to you about in terms of the data security and privacy aspects that are involved in a tech transformation project. Now, we're